Hi, everyone. Just giving you a second to get logged on and into the training. Thank you so much for joining us for part 2 of our Caregiver Custody Pro Bono training. My name is Jen Massey. I'm the Pro Bono Director at Children's Law Center, and I'm going to go over just a few quick items with you as we get started and do part 2 of today's training. If you have questions, feel free to use the chat function. And thanks again for being with us today. So I'm going to talk a little bit about the Pro Bono program at CLC, our virtual training series, a few things about today's particular training, and then also where you can find on-demand resources. So some of this will be certainly a reminder if you had already joined us for part 1 of this training. Looking to Children's Law Center's work, we are fighting so every child in DC can grow up with a loving family, good health, and a quality education. So you'll see on the screen that we work with hundreds of pro bono attorneys each year, and these partnerships allow us to serve more than 5,000 children and families each year. We can't do it without the support of our pro bono partners. We place pro bono cases in the 3 areas that we practice for family, health, and education. We're here today to talk about caregiver custody matters, where lawyers are representing third-party caregivers, often relatives, frequently grandmothers, who are caring for at-risk children who may otherwise enter the foster care system, but for this third-party caregiver who's providing a loving and stable home. There is great value in lawyers helping these family members move through the court process, and we'll talk more about that today. Supporting our pro bono attorneys. So you may have heard me say this before. We're screening our cases. We're thinking about which cases are appropriate for pro bono lawyers who have not done this work before or may be new to this practice area. We're providing trainings like today's, as well as other resources and materials on our website to support you. And we have those mentors on staff. Much like you heard yesterday, if you were doing part 1 or otherwise viewed part 1 of this training, Lauren Berzon-Harriman is one of our mentors. We have other staff at CLC who are mentoring in all of the practice areas where we place pro bono cases. So you'll have someone there to ask questions throughout the duration of the case, strategize about your next steps, thoughtfully think through the issues that you're seeing to provide effective representation for your pro bono client. Our virtual training series, these are the dates that we're doing these live, and then they're all recorded to be put on our website. So part 1 of caregiver custody training is already on the website, and this one will be on the website soon, or you might already be watching it from the website. I've highlighted on this slide a cultural humility training that I encourage everyone to view. We have resources that we've sent out if you were doing this training live with us for caregiver custody regarding client realities and cultural humility, and those are some slides that are specific to this practice area. The training that we have scheduled for July 23rd and will be made available on demand is going to cover the concept of cultural humility in a way that touches on all of our practice areas and cases, thinking about what it means to approach our work with cultural humility so that we can respect our clients as experts in their lives and effectively achieve successful outcomes for them. Touching briefly on today's training, so we are here for part 2 of caregiver custody. Part 1, of course, was covering the law and practice, thinking about the legal standard, going through the steps of a case from filing to closure. And today we're going to really dig into some special considerations for pretrial and trial. What are some evidentiary issues? How are you building up your case? What are some things that are happening at pretrial? These are the stages of the cases that Lauren is going to talk to you about today in part 2. As I said in part 1, these cases can be handled remotely. We have been doing this during the pandemic, representing clients remotely, using technology to connect with them, as well as participating in remote court hearings. We can provide guidance through our mentoring about this and keep you posted on changes as they come and as the crisis unfolds and in the future subsides. We also have questions. We can, of course, use the Zoom chat feature today, and we're here to answer questions outside of the training. So feel free to shoot me an email at any time. If you're watching this on demand, please feel free to reach out to me. Happy to answer your questions and support you as you're considering teaming with us and working with us on these matters. I will note that today we are going to, if you're joining us live, we're going to stay on, turn the recording off and stay on for 15 minutes just to engage around any of our available cases right now and questions that you might have from watching today's training. Again, if you're watching this on demand, go ahead and shoot me an email. Happy to answer your questions and engage with you as well. Those on-demand resources, the materials from our trainings, other materials like training manuals, videos, they're all on our website. You can go to childrenslawcenter.org, find the pro bono link at the bottom of the page, and you're going to get to this landing page that gives you a lot of different links on the right-hand side to connect you to some of those resources I just mentioned. Don't hesitate to reach out if you have questions. They are here to support you in doing this work with us. If you are interested in a case, please don't hesitate to reach out. We need your help. We're not able to serve all of the families that come to us, and pro bono lawyers are making a real difference. There are lots of advocacy skills you bring just by being a lawyer, and it can be a game changer for families. So please consider taking a case with us. I'm here to talk through what's a good fit for you and for the client, and happy to answer questions and support you along the way. I'm now going to turn it over to Lauren Berzon-Harriman, who is going to be doing part 2. You heard from her in part 1, and now she's going to dig into the pretrial and trial advocacy considerations for these cases. Lauren, go ahead and take it away.
Thanks, everyone. Give me just a moment to get my screen shared with you all. One moment. Okay, thank you everyone for joining us again today. We're so happy that you're back for part 2 of our pro bono training, like Jen said. A quick roadmap. Oh, I'm sorry, I'm going over things that Jen already covered, and let me zoom to the meat of this training today. So I want to cover some goals and give you a quick roadmap of what we're going to talk about today. So our session goals are really to understand best practices in pretrial and trial advocacy in custody cases in the District of Columbia. We also want you to be able to spot evidentiary issues that might be unique to domestic relations practice. And then finally, to identify concerns that are kind of specific to this era of COVID-19 and the pandemic. And so to achieve those goals, we're going to briefly review standards of law and burdens of proof in these cases. For those of you who have already joined us for part 1, it should sound pretty familiar to you. We'll walk through some important strategic considerations in the pretrial process. And we'll end with highlights about the substance and form of evidence in custody cases in the District of Columbia. As I said, we're going to highlight considerations about COVID-19 the whole way through. And just to kind of give you a preview of that, or to really hit home on the takeaway there, is that I think more than ever, pretrial advocacy and trial advocacy is a combined exercise with client counseling. With all of the changes that are happening in our world, in our clients' lives, in the court, it's really important to engage with your client and talk through important considerations with them the whole way along as you're advocating for them in the pretrial and trial process. So I said we're going to briefly revisit those burdens of proof that should look pretty familiar if you joined us for part 1. So in order to obtain custody of a child, a third-party caregiver has to establish that they have standing. They have to do that by a preponderance of the evidence. Once they have met that burden, they have to rebut the parental presumption by clear and convincing evidence. And then once they have rebutted the parental presumption by clear and convincing evidence, the court will assess whether it's in the child's best interest to award the third-party custody. And the burden of proof for that, again, is preponderance of the evidence. So that's the framework that it's important to keep in mind as you're advocating for your client through the pretrial process and through the trial process. One quick note is that the burden of proof applies even if the case is uncontested. So we talked in part 1 about best practices if you're proceeding in a default against a party, or if a party otherwise is not appearing for a trial or for a hearing in the case. The burden should still be applied. Some courts will be very clear that they are expecting you to apply that, to meet that standard in the law. Other judges may not be as clear about it, but it's still important to advocate for your client, to make your record, and to make sure that you are meeting the legal standards in the case. So we're going to talk a little bit about building the case. How do you get what you need in order to meet those burdens of proof and to prove a legal standard? So you want to be very thoughtful from the moment that you engage with your client about figuring out who the key people are with information relevant to your client's allegations, to the child's welfare, so that you can interview those witnesses and figure out who you might need to bring into court to advocate for your client. You want to review any records that are available in support of your case. So we always ask our clients early on in the representation to sign releases. If they already are the legal custodians for the child, sign releases so that we can get that child's educational records, medical records, anything else that would be really important for understanding why it is in the child's best interest for our client to have custody, because that's what the judge is going to be thinking about. What is in this child's best interest? You want to check social media for your client and for opposing parties in that case. And we can have a whole different training about social media. In fact, we have a former colleague who used to give one. And I unfortunately can't cover all of the great material that she does, but it is really important to keep tabs on social media. A lot of times clients or opposing parties may be posting things that either support allegations they're making or refute allegations they're making. When you're searching social media, you want to be very mindful not to misrepresent yourself or misrepresent your role. So it has to be clear who you are and when you are checking somebody's social media accounts. You also want to make sure that you're maintaining a good chain of custody. So that could include taking screenshots of social media to establish when the information was grabbed, how it was grabbed, who grabbed it, so that you could establish authenticity down the line if you needed to do that. Another method for building your case in these third-party custody cases is discovery. As I mentioned during part 1 of this training, discovery is not, it's not the rule in these cases. And the reason for that is that so many of these cases involve self-represented litigants who may not have the tools at their disposal to effectively answer discovery or to serve discovery requests. That's not to say that you can't avail yourself of discovery or that it won't be appropriate in some cases. I would suggest that if you are contemplating serving discovery in the case, talk with your mentor about some of the more nuanced strategic considerations. Okay, so raising issues before a trial. The way to do that in these cases is by filing motions. So if you have a concern that something needs to be changed, perhaps you need to request a change in a visitation schedule. Perhaps you need to request a change in communications between parties. Maybe you're going to be asking that there be a change in temporary custody, or that the court order engagement in a particular service, like, for example, that the court order that a home study be conducted on the parties' homes. The way to do that is by filing a motion with the court, either in writing or making an oral motion at a hearing before the court. It's very important to note that ex parte communications are prohibited in these cases. So ex parte communications would be any communication to the court outside the presence of the parties or their lawyers about pending or impending matters. The only exception to that is when no strategic advantage would result for any party. So it is okay to email chambers if you're planning to file a motion to continue and you want to know if the judge has dates available in July. What are those dates? There's no strategic advantage in reaching out to say, hey, what is the court's availability? It's not a proper way to make a request to communicate directly with chambers to say, we'd like a visitation change. The way to do that is by filing motions. We also want to talk a little bit about settlement negotiations, because many of these cases actually do settle, and settlement negotiations are a really important part of the pretrial process. There are a lot of different paths to settlement in these cases. So one path to settlement is through the attorney negotiator. An attorney negotiator is an attorney who is either an employee of the court or a volunteer who is available the same day to help mediate disputes between parties. And sometimes judges will send parties to the attorney negotiator if the judge is sensing that they're close together or that the disputed issue is really a small one. The judge may send the parties there to see if they can work something out the same day. The attorney negotiator program is not up and running right now remotely during COVID-19. I think there are hopes that an attorney negotiator may be available for custody cases soon, but just know that it's not a tool that's available at this specific moment in time. So if you hear about it, or if you want to use it but find yourself unable to, that's why. Another path to settlement is through Multi-Door Dispute Resolution Center. Multi-Door is the mediation arm of the court, which provides neutral neutral mediators, neutral independent mediators who can help parties reach an agreement in their cases. As I mentioned during part 1 of this training, sometimes parties will ask for mediation and end up at multi-door. Sometimes the judge will order the parties to do an intake at multi-door. Multi-door is up and running remotely now. There was a time that they were not, which has resulted in a bit of a backlog. So it may be that you have to wait a little bit to get into mediation with multi-door, but it's a great tool available when you think that having a neutral mediator might help move the case to resolution in a way that comports with your client's goals. You also should be mindful that you could avail yourself of alternative dispute resolution. So there are a number of attorneys who provide alternative dispute resolution in the District of Columbia, and many of them will provide pro bono services. So if you think that alternative dispute resolution might be an appropriate tool on your case, it's definitely an option to consider. And again, talk through it with your mentor, because we can help you think through the pros and cons and make sure that you know who might be available for ADR in these cases. Finally, I think very commonly, these cases involve a lot of informal negotiations. So it may be that you as the attorney are having conversations with opposing counsel. You may be having conversations with a self-represented litigant. Your client may be engaging in some settlement communications directly with the other party. All of those are options to consider. It is really important, if you are going to be engaging in settlement communications with a pro se litigant or a self-represented litigant, that you are very clear about your role. So our professional rules of responsibility require us to identify who we are as counsel for a party, and not to make it clear and not to allow the other party to believe that we're disinterested in the case, right? We need to disclose that it's our job to represent that third-party caregiver in achieving their goals. But you are permitted to engage with self-represented litigants around settlement, and often it makes sense to do so in these cases. The question of which of these paths you take is really a case-specific one. So it's going to depend a lot on the facts of the case. It's going to depend on your client's goals. It's going to depend how you think you might be most effectively be able to discuss resolution. So that's something to think through with your client, with your colleagues, and with your mentor at Children's Law Center. So we're going to turn to pretrial hearings and joint pretrial statements, which are another important part of the pretrial process. Judges have very different approaches to the pretrial process in terms of that time right before an evidentiary hearing. Some of them will affirmatively request joint pretrial statements and set pretrial hearings. Some of them will just do one or the other, and some of them do neither. If you want a joint pretrial statement and a pretrial hearing, and often we do, because especially where there are self-represented litigants, it's a really helpful tool to find out what the other party is planning to present, what their theory of the case may be, what witnesses they have, what documents they have. You can make the request of the court to have that hearing and invoke that formality. If you are the only attorney on the case, the judge may ask you to take a lead on filing a joint pretrial statement. That pretrial statement should include witnesses and exhibits. It might include any unusual legal issues that are going to be raised in the case. It might include stipulations that the parties are going to reach. So even if in these very hotly contested cases, we are often able to have some basic stipulations. For example, sometimes we may be able to stipulate to parentage or to a child's birth date or to certain facts in the history of the case. And we'll talk more about stipulations and their function, but the pretrial process is a great opportunity to hone in on those. You also want to make sure, if you're filing a joint pretrial statement, to note objections. So you may have objections to witnesses that are cumulative or who don't have firsthand knowledge. You may have objections to documents that are hearsay, that you may have authenticity objections, relevance objections. It's really important to note all those in the joint pretrial statement. Another important thing is that if you are having an expert witness testify, it's important to pay attention to Rule 26 and make sure that you timely file those disclosures that you need to file about expert witnesses. One more thing about pretrial statements. As I said, judges don't always require a joint pretrial statement. I like, when I'm representing a caregiver in these cases, to file my own pretrial statement, even where no joint pretrial statement is required. So I might file, you know, grandmother Mrs. Smith's pretrial statement, just stating my own witnesses, my own exhibits, my own issues. It's an opportunity for me to lay out for the court exactly what I want them to hear, what my client's position is and why, and to make sure that I'm providing that adequate notice to all the parties so that I'm creating a level playing field for everybody involved. We're going to turn in a moment to methods of presenting evidence, but I want to just pause for a minute and see if anyone has questions so far. I didn't say this at the beginning, but you're welcome to submit questions throughout the presentation in the chat. I'm happy to take them. I'm used to presenting this live and taking questions as they come, so please feel free to reach out. But with that in mind, I'm just going to pause for a minute and see if anyone wants to raise anything. Okay, well, if you do think of anything, please keep it coming. As Jen mentioned, we'll take more questions at the end, but we're going to talk now about the 4 primary methods of presenting evidence in these cases, namely witnesses, documents and exhibits, stipulated facts, and judicial notice. So it bears noting as a preliminary matter that the law of evidence in DC is largely based on case law. The rules of evidence in DC do substantially mirror the federal rules of evidence. So if you practice in federal courts or remember your evidence class from law school, it should feel very familiar. There are also some places where evidentiary rules have been codified or written in some way. So for example, General Family Rule Q talks about business records. And so that's an important place to turn if you're going to be introducing business records in a case. But otherwise, if you don't have a rule like that, you're going to be looking at case law for sources of authority in evidence. So we'll start with stipulations of fact. As I mentioned before, a stipulation is where the parties agree to the admission of certain facts without the presentation of evidence. And sometimes we get only a few stipulated facts like those I mentioned, and sometimes you can really get almost all your facts stipulated to and really just reserve those last few disputed issues for the presentation of evidence. The vehicle for presenting these is usually by providing a written list of stipulations to the court. If you can do that in the pretrial process, great. If you can't do it in the pretrial process, the judge will be very happy to take stipulated facts at any point in the process. So if I can't get to it by the time of a pretrial hearing, I might raise it as a preliminary matter on the day of trial to say that the parties have reached the following stipulations that we would like the judge to accept. Stipulations are great because they really help narrow the issues and make good use of the court's time. They promote judicial economy, and they kind of help the court and the parties to focus in on what really is in dispute in the case. So I would encourage you to try and reach stipulations whenever that's possible. The next method that we're going to talk about is presenting evidence through witnesses. So at the center of every case is always a child or multiple children. And then there are all these people that touch this child's life. So there's the parents and the caregivers. There are teachers. There are doctors. There are court officials like home study officers or evaluators. There will be other relatives. There may be social workers or therapists involved in this child's life. And all of those people are potential witnesses and therefore potential sources of evidence. We're going to talk more about child testimony specifically in a moment, so I won't pause on that here. But I think there are some really important things to think about during this pandemic about witnesses. So as Jen said, these cases, we are able to handle them remotely, and we've had a lot of success interviewing witnesses and locating witnesses remotely, engaging them either on phone calls or on Zoom meetings or FaceTime or Google Duo or whatever platform it is that they use. So it is still important to reach out to witnesses. Normally, I would recommend to you as a best practice when you get to trial to subpoena all of your witnesses. That may be trickier in the age of COVID-19 when we don't necessarily feel safe going out to subpoena somebody in person, or when the witness might not feel safe having you come out to subpoena them. So there are a few workarounds that I think you can think about. So one workaround is to think about whether that person might be willing to accept service of a subpoena by email. So Rule 45 governs subpoenas in these cases. It does not have a mechanism for subpoenaing witnesses by email, but a number of witnesses, especially those professional witnesses, the experts, the court evaluators, sometimes the teachers or doctors in the case may be willing to accept the subpoena by email and treat it as though it was valid service anyway. That is not, of course, exclusive to professionals. You can also reach out to relatives the same way. If you do have friendly witnesses, maybe there are relatives that are going to support your client. For example, you might be able to have those people join without needing a subpoena. So you can engage those people anyway. And then I think the final thing to think about and to talk through with your client is who is absolutely necessary to have in these cases. So if you can't get a witness, a particular witness that you would like to call in support of your client's case, should you move forward with trial anyway right now? In some cases, the answer to that might be yes. It might be that, you know what, I think we have enough and we can go forward. It may be, no, we can't get this witness and we absolutely need to wait until we can get this witness. So those are all things to think about. And those are really good conversations to have with your clients to say, here are the pros and cons of trying to move forward now. And here are the pros and cons of trying to wait, and engage your client in what's going to be better for their family and for their circumstances. I also will just very briefly kind of put a star next to the social worker bubble here. So one of the types of records that we often end up requesting in these cases where our caregivers have authority to request them might be records from any relevant Child and Family Services Agency investigations. If that's the case and you're thinking about introducing those records or subpoenaing a witness, please connect with your mentor on that point. So some of the mechanics for presenting evidence through witnesses, you want to interview all potential witnesses. So we've talked a lot about building your case, identifying witnesses in your case, but when you get the names of witnesses from other parties, you want to reach out to those folks as well. And to the extent that you can, try to engage with them so that you have a sense of what they're going to say and you can prepare your strategy for trial, whether that's cross-examination, whether that's an objection or something else. It's important to draft questions for witnesses in advance. So when you're doing a direct examination, you want to ask non-leading questions. When you're doing a cross-examination, you want to stick to leading questions. And in either case, you really want to stick to one question at a time so that the record that you're building is very clear. And then you want to prepare your witnesses for trial. So under any circumstances, you want to be talking to the witness about who's going to be in the room. If you were going to court in person, you might want to talk about who the judge is, what the layout of the courtroom is, how the trial works, who they should speak to when they're testifying. You want to practice with them the examination so that they have a sense of what kinds of questions you might ask, so that you have a sense of how they're going to answer and can really tailor your examination to their knowledge and their answers. You want to explain what to do when the witness forgets something. And all of that is still true during this pandemic. Those of you who joined us for part one yesterday heard me talk about how hearings have changed because of COVID-19. So all of our hearings right now in these cases are happening virtually through WebEx. Many lawyers and parties are participating by video. Some who can't participate by video are joining by phone. So you also want to prepare your witnesses for that. You want to make sure that you go through the instructions with them of how to join. You want to make sure you know if they're going to be joining by video or just by phone. You want to make sure that they're aware of who is going to be participating in this hearing. Who might they see staring back at them from whatever screen that they're looking at. You want to counsel them about putting themselves on mute when objections are being discussed so that there's not feedback. And also you want to counsel them about body language, eye contact, and presentation. So all of those credibility discussions that you would have in person, you want to have those same discussions about appearing remotely. It's just that the content might be a little bit different. So we're going to talk, as I mentioned, about child testimony a little bit, because the court is required to consider evidence about the child's wishes when that is possible. There was a case that came out in 2016, which many of the judges have interpreted to mean that the court should interview children when that's possible. There's been a bit of a sea change since that case. Before that case, we saw that judges were really reluctant to talk to children. They didn't want to bring children into court into the middle of caregivers' disputes about child custody. And while it certainly does not happen in every case the child comes into court, it does happen sometimes, and so it's something to be aware of. In the District of Columbia, all witnesses are presumed competent to testify, so even very young children. But they can be excluded from testifying if testifying might have a detrimental impact on the child. So there is a neglect matter that sets out a 3-part balancing test for precluding child testimony. The Court of Appeals has not explicitly applied it to domestic relations cases, which is where custody cases fall. However, we often do apply it by analogy in these cases. There's also a Court of Appeals case that says that the court can have children testify in camera as long as that testimony is recorded and made available to the other parties. So there are ways to set conditions that might help to protect a child. If you are thinking about calling a child to testify in your case, again, I would really encourage you to contact your mentor and strategize whether that's going to be necessary to achieve your client's goal. But it's possible that it will be, and it's possible that other parties may seek to call the child as a witness. And so it's really important to think through some of the considerations. So you want to think about the impact of testifying on the child. How is it going to affect the child's relationships with your client? How is it going to affect the child's relationship with other parties? You want to consider whether there's other means to get the same information into evidence. So I'm going to go through a few cases in a moment, but often the child may have made statements to other people that constitute hearsay exceptions that the court can admit through another witness's testimony. Children's wishes are also actually a pretty good place for stipulations. In many cases, it's not actually disputed what the children's wishes are. And so that's a way that allows the court to consider the child's wishes without having to bring the child into court. If somebody is asking for the child to testify, you want to take a position on whether it is in fact in the child's best interest to testify. And you want to advocate with the parties and with the court to advance your position. I will say, again, in the era of COVID-19, there are additional considerations to think about whether testifying is in a child's best interest. So in addition to all of the things that we might think about ordinarily, what it's like to talk to a judge, what the experience of coming to court might be like for a young child, how it might feel to have to talk about their wishes about one parent versus another parent versus a beloved caregiver. All of those are considerations that still apply. And now we have that extra layer of what it might mean for a child to appear remotely in a case. So for example, you might think about what it's going to do to a child's ability to build rapport with a judge and to feel safe talking to the judge. The child may have different perceptions of their level of privacy having a virtual hearing as opposed to an in-person hearing. And that might affect the way that the child presents himself or herself. It may also be that the child is going to present differently based on their location. So instead of coming into a courtroom where in most cases none of the caregivers would be present, it may be that that child being in somebody's house or in somebody's sphere of influence is going to alter the nature of their testimony, or is going to add that additional stress on the child of testifying. So these are all things that we at CLC are thinking about right now, and that we're happy to help you think through as well in your cases. I mentioned that there are often ways to get in a child's statements through other evidence. So there are no explicit exceptions to the rules of evidence in these cases, but the Court of Appeals has said that in these cases, the rigorous application of evidentiary rules are out of place, and that technical defects will not be given primacy over the best interest of the child. So what that really means is that the courts are going to try to construe the rules of evidence as liberally as possible in order to accommodate information in this case, in order to get information that they need to make a decision about what custody arrangement serves the child's best interest. There's another case that says that in many cases, the most probative evidence of a child's opinion might lie in statements that the child has made to others. So again, you want to think about whether there are hearsay exceptions that might allow those statements to come into evidence. Because I think that most judges recognize, and we as advocates certainly recognize, that a child coming into court does not have a pre-existing relationship with the judge, may or may not feel comfortable being honest with the judge, saying what's really on her mind. And so there can be limited value to having the child in court. Whereas if the child has a therapist that she has been confiding in, those statements may be able to come in under a statement for medical diagnosis and treatment. Again, there may be cases where you don't want the child's therapist to come into court because preserving that relationship is more important than the value it would add in your client's case. But that's an option to think about. Or it may be that the child has made excited utterances or said things that reflect their present state of mind. There's definitely room for creativity here and for thoughtful advocacy about what could come in without having the child come to court. So now we're going to turn to presenting evidence through documents. And we've got a list here of a number of documents that you might consider as helpful in your cases. So one thing that we sometimes will look for are certified copies of a DC criminal judgment and probation or commitment order. So if you have a party who maybe has a very lengthy criminal history that would be probative in your case, because not every criminal history is probative on a child custody case, but there are occasions when a party's history might be. Getting those documents and introducing them at trial may help your client prove your case. There may be documents in other jurisdictions as well that you can pull that would help prove your case. I will say that we've had a lot of success in DC Superior Court, at least, getting any records that we would be able to get in person. So the clerk's offices for a number of different branches and units have been responding to email, have been providing documents. So we're still able to pursue those even with court operations having gone mostly remote. It may be that in your particular case that the judge on his or her own initiative ordered drug testing, or that you requested drug testing, and those drug test results could be evidence in the case that you may want to introduce to court. You may have expert reports. So for example, if the parties underwent psychological evaluations or interaction evaluations where a psychologist assessed the interactions between the various caregivers and the child, you may want to introduce those reports as well. Home study reports similarly. So the court has a custody assessment unit where there are social service professionals who will go out to a home and assess for safety. And so that may be evidence that you want to introduce in the case also. The court does also have a supervised visitation center. So in cases where parties, either it is not safe for the child to visit with a party without the supervision of a neutral professional, or where the parties, the level of acrimony is so high between the parties, or for example, there's a domestic violence history such that it wouldn't be safe for the parties to do a direct exchange, the court may order them to avail themselves of the services of the supervised visitation center. And they do keep some brief notes. They're not very detailed in substance, but they do have notes that at the very least capture whether a visit happened, and that may be probative in your case as well. Finally, documents about the child may be very valuable, and you might wish to introduce those. So report cards, medical records, other teacher's notes, special education documents, all are potential exhibits in your custody case. It's important to remember, if you are going to introduce documents, to subpoena the authenticating witness. So you want somebody who can lay a foundation for that document, or even better, especially right now, you want to reach a stipulation that the document is admissible so that you can make sure that you've got that clear record, that you've laid that foundation. I think the same strategic thinking around subpoenaing foundational witnesses it exists during this pandemic. So it's another time to talk thoughtfully with the parties and with your client about what you can accomplish and any limits on what you might be able to accomplish, and help engage your client in directing the representation from there. I've talked about some of this. I have also should mention that when you're going to introduce documents, you want to think about not only about the basis for admission of those documents, but also of particular statements within them. So that maybe that there is hearsay within the document. Maybe you've been able to establish that a particular medical record is a business record and should come in, but there might be hearsay within that document that you want to be thinking through arguments about why it's admissible, or if it's not admissible, think about trying to redact it before submitting to the court. You want to prepare responses to objections that you're going to get in advance. And then you also want to prepare your documents and exhibits for trial. So that's going to mean making sure that they're labeled with exhibit numbers, making sure that you have exchanged them with the other parties. Again, before COVID-19, I would have advised you that when you appear for trial, even if you have already exchanged your documents, bring another copy for the court, bring another copy for the other parties, so that there's just no dispute whether anybody has gotten something. And it will also help to streamline things rather than having to pass one sheet of paper along between many parties for review. Everybody will have their own to review in the moment. Now that trials are being held over WebEx, I think the process is going to be a little bit different, and I think that judges are still working out for themselves what the submission of evidence is going to look like. So you can use the pretrial hearing to discuss how exhibits are going to be submitted over WebEx. Make sure that you have a clear direction for that, and so that you know what to do ahead of time. I will also say that objections during the time of WebEx hearings, it can be really awkward to not want to talk over other people during a remote hearing. Certainly the judges don't like it, but when you're lodging objections, it's still really important to make your record even though we're remote. It can feel even less formal than family court feels in person, but we do need to get those objections out, get those arguments out, and make sure that we make our record for our clients even when we're handling a trial remotely. Some common records rules that you should be aware of. So business records, as I mentioned, General Family Rule Q sets out standards for introducing business records. The court can take judicial notice of facts that are not reasonably subject to dispute within the jurisdiction. So that would include, for example, records within the same court. So the Superior Court can take judicial notice of its own records. Those are not reasonably subject to dispute. So if you are introducing a record from Superior Court, maybe the vehicle for getting that into evidence is asking the court to take judicial notice. You should take a look at Domestic Relations Rule 44 regarding certified public records, but generally certified public records are going to be self-authenticating. So if you're introducing, for example, a court document from another jurisdiction and you have a certified copy of that, that should be sufficient to authenticate that document. So we made it through a lot of material in a relatively quick timeline. I'm going to pause for a minute to see if you have any questions, because we're happy to take those. Okay, well, for those of you who might still have questions but are feeling a little shy about speaking up on the recording, I know we'll we'll hold on for a couple minutes. I'm going to turn it over to Jen just to wrap up with her thoughts.
Thank you, Lauren. Thanks for taking us through our part 2 of caregiver custody training. Echoing what you just mentioned, we can stay on after we turn the recording off if anyone would like to just engage with us off the recording. I have included in today's chat the evaluation link. Virtual trainings is something new for us, so we certainly appreciate your feedback. And if you are watching this on demand, feel free to reach out to us and let us know any thoughts of what worked, any questions that you have, areas where we can improve. Thank you again for joining us. So if you have not done part one is available, Custody Law and Practice, on our website. Go to childrenslawcenter.org. The pro bono button at the bottom of the page will take you to our pro bono page with links for various resources for the videos, the training manuals, etc. So thank you so much for joining. I'm not seeing anything come up in the chat. I'm going to go ahead and navigate through to stop our recording, and we'll stay on just in case anybody would like to engage with us about cases. We certainly need your help. I'd be happy to talk through some of the cases that we have right now and answer any questions. So thank you again, and I'm going to go ahead and stop the recording.